Hi everyone, my name is Brian Patchell. I'm the Group Manager for National Service Delivery here at the Ministry of Justice. Today I want to tell you about some changes we've made to the Criminal Legal Aid application form. Following some really good feedback that we've received from providers, from the New Zealand Law Society, from the Public Defence Service and internally, we've managed to take what used to be 3 forms of about 23 pages and render that down to one single Criminal Legal Aid application form, which is 6 pages long. We've managed to do that because of the, as I said before, the excellent feedback we've received from yourselves, so I really want to thank you for that. It's our focus to make sure that the interaction between providers and legal aid is as smooth and straightforward as possible, and what I believe we're going to be able to do now is increase the pace and accuracy with which we can consider your applications when they're coming in. This form will be available from the 25th of June 2018. Stocks will be throughout all the district courts, and you can also get stocks off our website. And on our website also is an editable PDF of that form, which means that you don't need to print anything out at all when you're completing them. That's it for today. Thank you very much.
Hi everyone, and thank you for taking the time to view this video. I'm Rihanna from Legal Aid Services, and I want to tell you about the key changes that we have made to the Criminal Legal Aid application form and what this means for you and our customers. In this presentation, we are going to talk about the themes that arose out of consultation and the changes to the form section by section. As you are aware, a proposed version of the Criminal Legal Aid application form was developed in May, and we went out for consultation via the Have Your Say page on the Ministry website. We received a lot of feedback from our Legal Aid Services staff, providers, New Zealand Law Society and the Public Defence Service. Our goal was to simplify and streamline our interactions with our customers when applying for legal aid. Consultation told us a lot about what we needed to improve on further. In particular, some of the major feedback we received from you was that the form required the following: a space for the maximum penalty of charges to be entered, a question regarding co-defendants, changing the audio-visual link confirmation for duty lawyers, having the hearing date and time on the front page. We have accepted these suggestions and you will see them as we go through the new form. The new form has combined information from the 5 forms listed here. Forms 1A, 1 and 12 will be withdrawn from use. The trust form and the statement of financial position will still be used for changes in circumstances. Here is what the new form looks like. Overall, we have combined the Police, Crown and Court of Appeal Supreme Court form into one, in a simple and efficient way. You will also notice that there is no longer a client cover page. The requirements have not changed for you to advise clients of their obligations, rights and responsibilities, but we found the dense wording did not make this easy for our customers to read. There is space on the top of the form for duty lawyers to write information relating to opposed bails. There is also space for the next hearing date and time on the top of the page to ensure that applications are prioritised correctly by legal aid staff. There are new and improved fact sheets underway to explain the legal aid process, and these will be more helpful for providers to direct customers to, along with information available on the website. An article in What's New for Legal Aid Lawyers will advise you when these are published. It is also worth noting that this form is now available in editable PDF. The living arrangements section has been changed and includes questions about co-defendants, the Mental Health Act and the Intellectual Disability Compulsory Care and Rehabilitation Act. We have modified the children question to clarify that it includes stepchildren, foster children and other dependents. The question asking how many children are living with the applicant is only asked in order to calculate work and income benefits. We have made it clear that we only need partner information where they are living with the applicant. This is the income details section. The key changes to note here are: we now only require details of current income as opposed to asking for the last 12 months. Information such as a weekly income will be sufficient. There is a tick box indicating whether the income is before or after tax. The benefit income received can now be indicated by ticking the relevant box. Information about future income can be included in the question, "Are there any other reasons why you can't pay for your own lawyer?" We do not assess the partner's income if the applicant or their partner are in prison. This is excluding if they are on remand for 3 months or less. A question asking whether a home, land or property is Māori land or on Māori land has been added. The land will not be included in the capital assessment. The original trust deed and the latest trust accounts are required if an applicant has an interest in a trust. We have removed the charge file date column from the criminal charges table as it is not information necessary for grants officers. The interests of justice question includes an other reason option to allow for other relevant details to be entered. This question should be answered for parole matters. For appeals, a copy of the notice of appeal is no longer required. We are now asking for the type of hearing for the next court date, for example, case review. The grants officer will advise the assigned lawyer of the type of hearing in the initial grant letter. Lawyer of choice is available for all appeal and parole proceedings and for charges that have a maximum sentence of more than 10 years in prison. For the lawyer of choice question, the applicant must sign their name to confirm that they would like the chosen lawyer assigned. Otherwise, a lawyer will be assigned by rotation. This does not need to be signed if the applicant is appearing via audiovisual link or for PDLA cases. The PDLA tick box is there so that grants officers can tell if a PDLA notification form has been received. When signing where the applicant appeared via audiovisual link, tick the box beside the part of the applicant confirmation. Sign the form and complete the information below the signature. When filling out the form on behalf of the applicant, please print your name and relationship clearly. The go-live date for the new form is the 25th of June 2018. Forms will be available to order from this date. Criminal courts and PDS officers will also receive copies before this. In the meantime, a link is available for the editable PDF on our website, which you will have seen in the What's New for Legal Aid Lawyers article. Thank you for taking the time to watch this video. We really think it will improve the efficiency of legal aid administration by making it easier to assess eligibility and improve services to our customers. I hope I have answered any questions you have, but if you have any other questions, please contact us at nsdopsupport@justice.govt.nz or 0800 2 Legal Aid. Thank you.